Hello and good day, everyone. This is to warmly welcome you to the 17th edition of Legal Insight. Today is Sunday, the 7th day of June 2026. In this edition of the program, we will continue from where we stopped last week. You recall that in the 16th edition of the program, we were able to discuss meaning and types of shares as well as preemptive right of shareholders. In continuation of that discussion, today we will begin by looking at the procedure for allotment of shares of both public company and private company. For a public company, the first step toward allotment of its shares is the approval of the company or the board of directors, authorizing allotment of specified numbers of shares. After this, an application will be made to the Securities and Exchange Commission to authorize the allotment in the first place and also authorize issuance of prospectus or a document in lieu of prospectus. Prospectus simply means a document containing the terms and conditions of the allotment and also application form for the allotment of shares. Now, upon approval of SEC, an advertisement will be made inviting members of public to subscribe to the shares of the company. Upon receipt of applications from members of public, the meeting of the board of directors will now be convened in order to consider the applications and also make allotment of shares. Now, after this, another application will be made to the Securities and Exchange Commission in order to approve the allotment made by the board of directors of the company. Now, upon approval of SEC, the letters of allotment will be issued to successful applicants, and this will subsequently be followed by issuance of share certificate. Now, for those whose applications were not successful, later a grade will be issued to them. Now, after this, the name of the successful allottee will be entered in the register of members of the company, and the company will now file return of allotment with the Corporate Affairs Commission. From the foregoing discussion, it is very clear that the main distinctions between the procedure for allotment of shares of public company and that of private company are that, in case of public company, there has to be approval of the Securities and Exchange Commission. In addition to that, for a public company, it is allowed to invite members of public to subscribe to the shares of the company, whereas the procedure for the allotment of shares in case of private company does not require the approval of Securities and Exchange Commission. A private company is also not allowed to, invite members of public to subscribe to its shares. Payment in respect of shares can be made either in cash or other valuable consideration. This means it can be cash or in kind. In fact, the Companies and Allied Matters Act allows for the combination of both cash and kind. Now, it is important to state that where any amount has not been paid in respect of share held by a shareholder, the company is at liberty to request such shareholder to offset such unpaid amount. This is known as call on shares. Now, where call has been made and a shareholder fails, or refuses to offset the unpaid amount, the shares held by the shareholder is liable for forfeiture by the company. And where such forfeiture has been made, the shareholder ceases to be a member of the company. This brings us to the conclusion of this edition of Legal Insight. In the next edition of the program, we are going to consider transfer of shares and transmission of shares and other, relevant things in relation to shares. Thank you for watching and have a nice day.